How to construct a rule, torts edition. Ladies and gentlemen, by popular demand, we're going to spend the next few minutes talking about the best way, or maybe one efficient way, to think about constructing a rule. Or maybe better yet, I should just tell you this is how I would do it, or how I think about it, right? And it happens to line up with how I'm trying to evaluate you guys. So, my first point is that in advance of your evaluation, right, you know what the subject matter is. We have to make sure, you have to make sure that you have a generally applicable principle that you associate with each potential cause of action, all right? GAP is what I've called it in class, generally applicable principle, because rules are cool, and I don't think you can construct a good rule without a gap. GAP, generally applicable principles, are those generic facts, right, that would lead one to believe that a certain cause of action is involved, and that is without respect to the specific facts of the hypothetical that you may be presented in an exam, right? Because this is generic facts that would lead anyone, in any case, with the same information to believe that a particular cause of action is involved, right? So for intentional torts, it can be helpful to formulate your generally applicable principle using my tried and true defendant intentionally, right? Because we know that there are 16 of the intentional torts that we've talked about in class, right? I would suggest that we start with each case, right? A defendant who intentionally acts is liable for blank, the blank being the name of the tort, and the X being the unknown, because we know that you're constructing these generally applicable principles prior to your being tested on them, right? So you don't know what the X is yet, right? So we need to look to each of the causes of action in order to determine what the appropriate X is to fill in, right? Because we've already said a defendant who intentionally does something is liable for whatever the tort is. So we would go and look at that tort. X is the generic facts, a description of the generic facts that lead to your choosing the particular tort, right? So you need to review those 16 torts in order to understand why you would particularly choose one cause of action versus another. Why would you pick intentional infliction of emotional distress as compared to defamation, as compared to assault or false imprisonment, right? So we know we have to look back to the facts. Here's one example. Facts. Bob assaults Laura, right? She immediately has a PTSD episode and is hospitalized, right? So if I've charted out all of my intentional torts, and I know I'm being evaluated on intentional torts, I would look and I would probably find that I've run across one called intentional infliction of emotional distress. And it has a couple of points that we can use to characterize the facts here, right? So that's what we're looking for. We're looking for, in this generic, generally applicable principle, something that we can use to characterize the facts and the fact pattern that we've actually been given, right? I hope I don't make that sound easier than it is or more difficult than it is. It just requires a bit of thought, right? So here, a defendant who intentionally commits an outrageous act causing severe emotional harm is liable for intentional infliction of emotional distress. So we've got a couple of elements here, right? Remember I said that rules should have elements. A defendant who intentionally commits an outrageous act, so we've got that. We've got the defendant intentionally, which is an act because it has to be intentional, right? We've got the outrageous act, right? And then we've got the result, which is severe emotional harm, right? So can we use that to characterize what Bob did to Laura? That is the question. So why would I pick that rule, right? I know the generally applicable principle for the tort in advance. So it's not as taxing for me to think, oh, well, which one could that possibly be? But obviously, you guys are just starting. You need to have that kind of considered in advance, right? I characterize the assault that Bob commits on Laura as outrageous. It's not unreasonable. Is it acceptable? No. Well, then it's not a leap uh, to argue that it's beyond all bounds of human decency, which, or some other such similar description. Simply the word outrageous is enough because that's the one that's present in the generally applicable principle that I selected. I also characterize her PTSD hospitalization as evidence of severe emotional distress. Right? I mean, it's not simply her going home and crying, right? She had to be hospitalized because she felt like she couldn't function. So that seems to be more than simply garden variety emotional distress, right? So hopefully you will see how the fact pattern and the gap and the cause of action are all related. That's why we research the generally applicable principles in advance to find generic facts that we can use to describe each tort, right? And so there are 16 of the intentional torts, the 11 intentional torts against persons, assault, battery, false imprisonment, infliction of emotional distress, defamations, times two, libel and slander, each of the invasions of privacy and appropriation, fraudulent misrepresentation, the frivolous litigation / abusive process tort, and the tortious interference with contract tort, and the tortious interference with business relationship tort. Right? We also had the intentional torts against property. All right? There is the trespass to land. There is the trespass to personal property. There is conversion. There is slander of quality and slander of title, or what we call them, business defamation or business libel. All right. In addition, just to be complete, we've got the unintentional tort of negligence. We know the rule there is duty, breach, causation, damages, right? So that's one rule that you can chart right there, right? Strict liability is absolute liability. We'll get more into that when we talk about product liability. But for now, it's sufficient for you to know that it includes activities that can't be made safe and undomesticated or dangerous animals, right? No fault, not liability schemes, right? So the generally applicable principle is the basis for your rule, right? It won't always be the best expression of your rule, however, because you don't know the facts of the fact pattern in advance, right? So for the beginning law student, you have to remember that the fact pattern itself might sound in the basic gap or the principles that you've come up with to define each tort, but then it may also sound in some other related rule that you have to keep in mind, right, in order to respond, because that's why it's never just an open and shut case, or rarely is anything an open and shut case. So incorporating your gap into your rule, you have to keep any additional or superseding rules in mind. Anything that might impact the rule or the generally applicable principle that you have selected. For example, First Amendment limitations on emotional distress claims. We looked at that when we talked about the Larry Flynt versus Jerry Falwell, the televangelist case, right? And also the distinction in defamation between libel and slander for damages calculations, right? Those types of rules might impact the fact pattern depending on what the fact pattern is. So in addition to knowing the basic generally applicable principles that you want to talk about with regard to the tort itself, there may be other rules that impact on that rule, right? But at the very least, each tort should have its own, or in the case of any other, legal principle, because we're talking specifically about torts here, but it is applicable to more than just that. It's, the basis of breaking down a legal problem is to be able to figure out what generally applicable principles are going to make sense to apply here, right? So, with regard specifically to negligence, there are many of these extra rules, right? Special negligence doctrines or defenses, right? So just be aware that they exist and be nimble enough to be able to consider them if the fact pattern warrants it, all right? So, for example, but-for versus proximate causation, superseding cause, right? Those types of questions. Or what level of care is applicable in a particular situation? Is it the reasonable person standard or is it the reasonable doctor standard? Well, it depends on what that person, whether that person is a doctor and what that person was doing at the time that the injury arose, right? It would probably require them, for example, to be providing medical care, right? So the understanding the nuances in some of these rules is also a part of it, right? For those of you that are in Business Law 2, this is just a refresher. For those of you in Business Law 1, this video is followed by a quiz that is entitled appropriately How to Construct a Rule, Torts Edition. You'll find it in Canvas under quizzes, and I look forward to reviewing your results and to giving you feedback. For Business Law 2, folks, I'll have another activity up for you, but this was just by way of review. Thank you very much for your time, and I hope that everyone is both safe and snug and healthy. All right? Take care, and I'll see you soon.